Hello, everybody. It'll be a pleasure to be here with you. I'm Marina Castro. I will be the moderator of this speech. First of all, I would like to introduce you the panelists. Mr. James Aquilina is attorney of Quarles and Bread in Washington, D.C., as well as he serves as editor-in-chief of Quarles and Bread, protecting the product design rights law. He is also immediate past chair of the Industrial Design Committee of AIPLA, known in Brazil as IPLA, a member of INTA, known in Brazil as INTA, Design Rights Committee, and a frequent speaker and academic contributor on US design law topics. Mr. George Hudson is a senior associate of Venus Shipwood. He is also a chartered UK and European patent attorney and design attorney. George also lectures on various aspects of design law, including the UK Chartered Institute of Patent Attorneys. Mr. Raul Murat is a doctor and master in civil law from State University of Rio de Janeiro, professor of law at Pontifical University of Rio de Janeiro, partner of Denis Borges Barbosa Advogados. Thus, now I introduce how will be this presentation. It will be like a conversation. We would like to be this in a more dynamical way. So, the first part, Mr. James Aquilina and Mr. George Hudson will present you some aspects of the ordinary observer test and the informed user test. And after that, we'll do some discussions with some spots, including Mr. Raul Murat. After this first part, Raul Murat will present some Brazilian infringement cases, and we will prepare some spots as well. Please, if you would like to send a question, do along the presentation by chat, and at the end, we will open for this. I hope you enjoy this presentation, and I invite Mr. James Aquilina to start.
Thank you, Marina, for that introduction and for the invitation to speak here. It's an honor for me to present to the Congress. I wish we could all be in person for a meeting, but this is the next best thing, and at least we can only get half dressed to do it. Let me share my screen here. Please let me know, Marina, if you see any issues.
Okay.
And my audio is okay?
Yeah, yes, audio is perfect.
Okay. So what we were asked to present on today is the infringement test for industrial design law, comparing the US standard to the standard in the European Union. And so I'll present for 10 or 12 minutes on the US test, then George will present on the counterpart test in the European Union. And then we'll kind of compare and contrast some of the finer points of this. Then after Raul presents, we will have some questions from Marina and from the audience on some of the finer points of how courts look at the infringement test in this context. So the seminal language from a very old United States Supreme Court case from 1872 is the ordinary observer, but this is shorthand for a finer test. I'm going to start here, which is with a couple sections of the United States patent law that talk about one section in particular, which talks about a special remedy for infringement of design patents. And there aren't too many countries that, in my knowledge, have this type of remedy, but essentially it allows for a recovery of total profits of the infringer if there's infringement of a design patent. Now, the reason I bring this up in the context of a discussion about what the infringement test is in the United States is that this section of the law, this is a 35 USC 289, uses the language colorable imitation. And so this must mean the standard that has come about via case law. This must be equivalent to that standard for infringement that's come about through the case law, which is how law is created in a common law jurisdiction in the United States for the most part. One point to make before we dive into the standard, which is that in the United States, we have design patents. We have substantively examined patents on novelty, on non-obviousness, and on various types of definiteness. And therefore, because these are patents that take 2 years to to be obtained and are scrutinized carefully, they are entitled to a presumption of validity. And we'll get into discussions about validity in this design patent context, but very different than the EU, where you have, an examination on formalities only, and then something that is not considered valid per se. So this is the seminal test from the year 1872, Gorham v. White, and it involved some flatware, some forks and spoons that had various handle designs. And this is a test that the U.S. Supreme Court developed at the time in this case. In the eye of an ordinary observer, giving such attention as a purchaser usually gives, and we'll unpack this a bit later, two designs are substantially the same if the resemblance is such as to deceive an observer, inducing him to purchase one, supposing it to be the other. So there's a few different points here. So ordinary observer, that gives the level of attention that a purchaser usually gives. And then substantial similarity, and that has to be, so substantial similarity has to be equal to colorable imitation. Again, that language I showed you. So those are kind of synonyms of each other. This is further language from this Gorham v. White case. So whatever differences there may be between the plaintiff's patented design and those of the accused infringing design, there has to be so much alike that in the marketplace with purchasers who, again, would give the ordinary level of attention when purchasing articles of that type, they would be in danger of being deceived as to the source. So much so that even persons in the trade. Okay, so there's a standard here that's an ordinary observer and purchaser of articles of that type who is deemed to have some knowledge of what exists in the art. There's a long time between 1872 and the next case, which really unpacked this test, 2008. So, 130 years later, in the United States Federal Court of Appeals for the Federal Circuit, which is our highest level appeals court for all patent matters, took up this question of what the design patent infringement test really looked like in this ordinary observer test. And stepping back for a moment, in the interim between 1872 and 2008, many of the district courts who actually try these cases of design patent infringement had developed something of what's called a point of novelty test, which arose out of this, again, this case law and attorney argument, and which took the position that the ordinary observer test needed to focus on, quote, the appearance that distinguishes the patented design from the prior art. So what was argued by many attorneys in many cases, in some cases successfully for many years, was that when you applied the ordinary observer test, you needed to focus on those things in the patented design that distinguished it from the designs in that area, in that art field, which existed prior. The Federal Circuit Court of Appeals in this Egyptian goddess case, which is a great name for a case, rejected that there's this separate point of novelty test, and held, and looking at the quote at the bottom there, the proper inquiry is whether the accused design has appropriated the claimed design as a whole. No focusing in on individual points of novelty or sub areas of the design, right? You have to look at the accused design as a whole and say, is it substantially the same as the patented design as a whole? What this Egyptian goddess court held further was that the ordinary observer, looking at the quote at the bottom here, the ordinary observer comparing the claimed and accused designs in light of the prior art, that will automatically attach importance to the differences between the claimed design and the prior art, depending on the overall effect of those differences. So there's not a separate step of identifying the points of novelty over the prior art, but the ordinary observer is deemed to have some knowledge of the prior art, of what exists. And effectively, what's established here is a three-way comparison test, excuse me, which exists unless the claim design and accused design are sufficiently distinct. So if I bring a case for design patent infringement, if the court or the fact finder can hold that the accused design is sufficiently distinct from the patented design, then we don't need to look at the prior art. Then the inquiry ends right there. There's no infringement, right? But if we can't do that, then we have to pull in the closest prior art, and we have to apply this ordinary observer test, comparing the claimed and accused designs in light of the prior art. The idea being there that, again, this ordinary observers, and then this pulls in the language of, giving the level of attention that purchasers usually give, or what does the prior art show, and would the ordinary observer think that the new elements in the overall accused design are they kind of closer to the prior art, in which case it's probably not infringement, or is it still closer to the patented design, by essentially evidencing that the person who brought the accused infringing design to the marketplace likely adopted design elements more, and the overall accused design likely more from the patented design than they did following more what was in the prior art to the patented design. So to summarize this infringement test, substantial, a finding of infringement of design patent, finding of design patent infringement in the US requires that you find substantial similarity of the overall designs in view of the prior art, unless the designs are plainly dissimilar, in which case there's no need to review the prior art and there's no infringement. Now, again, the nature of the article matters, and the level of the sophistication level of the purchaser for that type of article matters, because of this language from the original Gorham v. White US Supreme Court case, giving such attention as the purchaser usually gives. Important point here, and we'll talk more about this in the context of our kind of joint conversation about validity. But the infringement test in the US, as I just discussed, is not the same as the validity test for design patent. The validity test uses this designer of ordinary skill language and looks at whether that designer of ordinary skill who makes that type of article was considered obvious to modify or combine existing designs to arrive at the patented design. So it's not an ordinary observer, it's a ordinary purchaser who has some knowledge of the prior art. And when they buy a nail buffer, which was the subject matter of the Egyptian goddess case, a nail file, what level of attention do you give when you buy something to file your nails? Probably a little bit of attention, but not a ton of attention, right? The validity test is a more strict test, and looks at the designer of ordinary skill who makes that type of article. You'll see when George discusses here that that's different from what the validity test discusses in the European Union. Just a couple of related issues. Design patent eligibility in the US requires that an entire design is not functional. Some of the language that we use is, this is kind of old language, but de jure versus de facto functionality. In other words, is the entire design required to look that way because nothing else could perform that function about as well as that, unless it looked like that. If so, then a design is considered functional and ineligible for design protection in the US. But I know of exactly one case in which a design was held by a court of appeals in the US to be functional, and that was a key design, door lock key design. And they basically said, well, that key blank design has to look that way because there's a mating lock out there. And so therefore every bit of that key blank has to look exactly like that in order to mate. Now, I think that case was actually wrongly decided, but functionality is not a major hurdle in the United States, because we look at the overall test and the existence of alternative designs that can form that a similar function, essentially makes it so that a finding of functionality is not likely. Looking at the right-hand side here, this second bullet point, the first bullet point on functionality, right? Even functional elements that are claimed in a design patent are still part of the overall claim design because their placement in space is part of the design. If you have an outlet or a plug on a vacuum, the selection of where that outlet would be placed in three-dimensional space with respect to the rest of the vacuum, well, that's a design choice. Going to the second bullet point here, claim construction is flexible. And so courts can allow the fact finder, or can, if they're themselves the fact finder, de-emphasize these elements that are per se functional, but they can never filter them out of the design patent analysis. They're still part of the ornamental design, and they have to be considered in the context of the overall design. So you can de-emphasize some of those things that are kind of required to be there, but you can never remove them from the overall design analysis. And then going back to the left-hand column here, there are no protection exemptions in the US. We have no, they're just in the US, in the EU parlance, the language that's used, there are protection exemptions for must match design. So fender of your car, you get in a car accident, you want to replace it so that the car looks original. Well, we don't have an exemption for design patent protection in the US for that. And then you have what's called must fit, again, using the EU language there. So if you had like a plug or something that had to have a shape to fit, it would only be functional in the US if the entire design had to look that way. In other words, if there was no alternative designs for the total design. So if you had a plug, a prong of a plug, which, the US has a standard, Europe has a standard, the UK has a standard, the prong portions have to look a certain way, but the rest of the thing doesn't have to look that way necessarily. And so if the claim design is just on those prongs, then it's probably functional in the US, but because it must fit, right? It has to be shaped that way to fit something that already exists. But if there's more claimed, the rest of the plug, then the overall design would not be considered functional. So functionality, long story short, functionality is not a major hurdle in the US for design patent infringement. Not an issue that typically results in invalidation of US design patents. And I think we're holding questions. Is that right, Marina? I wanted to keep this short and sweet and let George talk, and then we'll kind of talk about some of these finer points in a conversation type format.
Yeah, James. We can put these questions to the end, and now George can present his point of view about Europe.
Thanks, Marina. Thanks, James. I'm just going to share my screen here and get my slides up. Okay, so yes, first I'd just like to echo James's sentiments in thanking you all for the invitation to contribute here. It's a great privilege, and I fully agree. It's a real shame we can't all meet in person. So I'm going to be talking about the European perspective on infringement and the informed user test. I'd like to start by giving a quick word on the legislation. There's really two major pieces of EU law you need to be aware of here. The first is the Community Design Regulation. Now, this provides basis for the registered and unregistered community design systems. So these are pan-EU rights. They cover all 27 EU member states, and they're obtained via a single application, and they can be enforced via a single action in one designs court. So it's possible to get a pan-EU injunction. And the second piece of legislation is the Community Designs Directive. This is the effect of harmonizing most aspects of the national registered design law of member states. So most aspects of registered design law in member states, in Germany and France, for example, they essentially mirror the registered community design system. And this is good news for us because it means that in this talk, The informed user test we're going to talk about applies to community designs that have extent in the whole of the EU, but also the national registered systems. Finally, I'm just going to mention briefly the United Kingdom. Obviously, we've left the European Union now. So from the beginning of this year, community designs no longer have effect in the UK. But we do have our own UK Registered Design Act, and that was previously harmonized by the Community Design Directive. So currently the provisions are still the same. So it's, again, the same informed user test is applied in the United Kingdom. Although now we of course have scope to diverge from that in the future. So just to briefly touch on what a design is in the statute, Article 3 of the regulation defines a design as the appearance of the whole or part of a product resulting from the features of, in particular, the lines, contours, colors, shape, texture, materials, and/or ornamentation. And product is also defined as any industrial or handicraft item. This includes parts that are intended to be assembled into complex products, and we'll talk a bit more about this in a moment. Also packaging, get-up, graphic symbols, typographic typefaces, but excluding computer programs. This computer programs provision is actually intended to exclude the underlying software code, which is covered by our patent and copyright systems. The appearance of computer programs is still protectable under design law. So computer icons, for example, and graphical user interfaces are protectable. Now, I'm going to quickly talk about validity. And the reason for this, well, James has already mentioned, we have a mirror test here for validity and infringement. So that we'll see that the way validity is assessed is the same as the way that infringement is assessed. So Article 4 of the regulation requires that a design should be protected to the extent that it's new and has individual character. And a design is new if no identical design or design differing only immaterial details is known. Individual character. A design has individual character if it produces a different overall impression on the informed user than any other design made available to the public. So if you have your design and you have a prior art, if looking at these designs, the informed user considers they have the same overall impression, then the design would lack individual character. And as we can see in Article 10 of the regulation, we have the mirror test for infringement. The scope of the protection shall include any design which does not produce on the informed user a different overall impression. So if you take the design and a third-party product, if they produce the same overall impression on the informed user, the product would fall in the scope of the design. And the courts have established a four-stage examination for assessing individual character and also infringement, because we're looking at the overall impression. These are taken from the statute, and I'll cover each of these in turn in a second. But the first stage is deciding on the sector of the products in which the design is incorporated. We then have to identify the informed user and decide firstly on the user's degree of awareness of the prior art and the level of attention in the comparison, direct if possible, so side by side. We have to look at the designer's degree of freedom in developing the design. And then in the fourth step, we assess the outcome of the comparison, taking into account the sector, this degree of freedom we've discussed, and the overall impressions produced on the informed user by the contested design and any earlier design. So looking at the product and sector, we need to look at the nature of the product when we're assessing the overall impression, and the industrial sector to which it belongs, and the manner in which it is used. And we've actually seen that courts will look at features that might be similar between a design and prior art or an infringing product, and they will look at how visible these features are in normal use to attribute how much weight they would be given by the informed user when assessing whether the same overall impression is produced. Moving on now to the informed user. As IP practitioners, we're often accompanied by our imaginary friends. In patents, we have the skilled person who helps us to establish whether an invention has inventive step. In trademarks in Europe, we have the average consumer. And in designs, the notional person is the informed user. And the concept of who the informed user was explored in the case of PepsiCo and Grupo Proma. This case concerned PepsiCo's registered community design, shown on the left, to a POG or Tazo. It's a promotional item, a children's toy that is placed in packets of crisps or potato chips. Grupo alleged that PepsiCo's RCD was producing the same overall impression as Grupo's own earlier community design. This is shown on the right here, and that therefore PepsiCo's design lacked individual character. So the court had to decide upon the identity of the informed user. If on the one hand, the informed user was the reasonably observant and circumspect average consumer, who normally perceives a design as a whole and does not analyze various individual details, then it's likely that differences between the design in question and earlier designs would be overlooked, and therefore the same overall impression would be given and the design would be found invalid. If, on the other hand, the informed user was an expert or a specialist and they were capable of observing in detail minimal differences that may exist between the designs, it's more likely these differences would be noticed and picked up upon and would produce a different overall impression, in which case the design would more likely to be valid. In the end, the Court of Justice of the European Union took a position between these two extremes. They decided that the informed user is somewhere between that of the average consumer, applicable in trademark matters, who need not have any specific knowledge and who, as a rule, makes no direct comparison between the trademarks in conflict. And on the other hand, the sectoral expert, who is an expert with detailed technical expertise. So they held that an informed user has a professional or personal interest in the design. They're not a designer, they're not a technical expert or a manufacturer or a seller, but they do have a high degree of attention when using the product because of this interest. And they are, after all, they're an informed user, they're not just a user. So they're particularly observant on account of their knowledge of the sector and the existing design corpus. And they'll usually perform a direct side-by-side comparison of the two designs in question, unless this would be impractical or uncommon in the sector. So in the present case, interestingly, the informed user was either a child aged 5 to 10 years old, or a marketing manager of a company that makes goods that were promoted by giving away the POGs or Tazos, so a marketing manager in a crisp company or potato chip company. The court held it didn't actually matter too much who the individual was. They're a notional pretend person. The important point was that both categories of person are familiar with this phenomenon of POGs or Tazos. In the end, the relatively minor differences were held to be insufficient to produce a different overall impression, and therefore PepsiCo's later filing lacked individual character, produced the same overall impression, and so was invalid. Moving on now to this concept of the degree of freedom. This is defined in Article 6, when just talking about individual character, and Article 10, when we're discussing infringement. The degree of freedom of the designer in developing his design shall be taken into consideration. So we have to consider how many different shapes or appearances can a product have whilst achieving the same function. It might be that the design in question and the prior art has a particular feature, but it has this feature because there's not really many other ways of making this feature because of some sort of functional constraint. If there's a greater design freedom, it means that it's less likely that minor differences will be enough to produce a different overall impression on the informed user. On the other hand, if there's less design freedom, it means it's more likely that minor differences will produce a different overall impression. And now turning to the design corpus, if there's a feature of a design that's a significant departure from the design corpus, for example, some striking new feature that hasn't been shown before, then this is likely to be noticed by the informed user who's aware of the design corpus, and therefore it will be given greater prominence. So if a third-party design also has this striking new feature, there's more likely to be a similar overall impression and a finding of infringement. So the informed user will give less significance to features which are sort of well known from the design corpus. We also have the concept of the crowded field. So if there's a lot of prior art in a particular area, and it all looks quite similar, the informed user is more likely to notice small differences when assessing the overall impression. So in such a situation, the design is more likely to be valid because these small differences are more likely to give a different overall impression. But on the other hand, it's more likely that the scope would be quite narrow because, again, small differences that a third-party product has over the design in question would produce a different overall impression. So it's a bit of a double-edged sword. I'd now just very briefly like to talk about a case, Samsung and Apple. This was a UK court sitting as a community design court. It involved the Apple iPad RCD on the left and the Samsung Galaxy Tab shown on the right here. So Samsung had applied for a declaration of non-infringement, and Apple alleged there were 7 features common to the design and the Galaxy Tab. And the court actually considered each of these 7 features in turn, taking into account the existing design corpus and the degree of freedom to determine how significant each feature was to the overall impression. So it's quite an interesting case because it embodies some of these principles we've talked about. I'm just going to look at one of these features. This was the first feature, a rectangular biaxially symmetrical slab with 4 evenly slightly rounded corners. So this was the first feature that was alleged to be common to the community design and the Samsung device. The court held that the rectangular display screen is totally banal and determined solely by function. And the broadly rectangular shape of the device was driven by the function of using a rectangular screen. It was noted that the devices did not need to be exactly rectangular or biaxially symmetrical, so there was some degree of design freedom. But this feature was so well known from the design corpus anyway that it wouldn't be given much significance. It was also held doubtful that a designer would produce a tablet with sharp 90-degree edges. So the rounded corners was also given less prominence. There was some constraint on design freedom here. So therefore, overall, the significance of this first feature is reduced. I think it's very important to stress here that although courts do like to sometimes break these designs down into individual features, the actual test for overall impression has to be approached considering the designs as a whole. So although you can break the design down into these features and look at how much prominence the informed user will give to each of these features, taking into account the design corpus and the degree of freedom, in the end, the comparison has to be of the 2 designs as a whole. In this case, actually, it was quite a famous decision. The court held that the Samsung products are very thin. They did not have the same understated and extreme simplicity as the Apple design, and they were not as cool. So in the end, there was a different overall impression and a finding of non-infringement. Lastly, I'd just like to summarize some of the exclusions that are present in European law. I think we're going to discuss these in a bit more in a second, but I'd like to quickly run through them first. Firstly, for component parts of complex products, so that's products that have multiple parts, the components are only protectable to the extent that the part remains visible during normal use of the device, and that's used by an end user. So features which are hidden wouldn't be protected. We also have this repair clause. This is the must match exclusion James mentioned a moment ago. Protection shall not exist for a design which constitutes a component part of a complex product for the purposes of the repair of that complex product, so as to restore its original appearance. So it applies, for example, to the bumper analogy James mentioned, where your car fender is broken. A third party can freely produce another bumper, but it's only for the purposes of repair of a product. So there is a limitation there. We also have the must fit exclusion. So features that need to be reproduced in their exact form and dimensions to permit the product to be connected to another product would be excluded. There is, however, an exception to this. Features that it doesn't apply to designs that serve the purpose of allowing multiple assembly or connection of mutually interchangeable products within a modular system. I've heard this colloquially called the Lego exemption. If you imagine the raised nodules on a Lego brick, those features, although they are necessary to allow connection to another brick, they're not necessarily excluded because the Legos are a system of mutually interchangeable products. We also have an exclusion, protection shall not subsist in features of a product which is solely dictated by its technical function. This is quite important. If a feature of a design is there purely for technical reasons, it should not be afforded design protection. And finally, we have an exclusion for designs that are contrary to public policy or to accepted principles of morality. So that concludes my run through. I think now, are we going to take some questions, Marina?
Thank you very much, James, and thank you, George, for the splendid talk about this test. Now let's prepare some sports for you, including Haumura in this discussion as well. First part, James, when we apply the three-way comparison, is to define how the details are relevant to the design patent. George, do you think that is comparable with the definition of the degrees of freedom of the informed user test? Could you explain about this?
I have to apologize, Marina, because I didn't quite clearly hear your question. Would you mind repeating it?
Yeah, for sure. James, when we apply the three-way comparison, is to define how the details are relevant to the design patent. And for George, do you think that is it comparable with the definition of the degrees of freedom of the informed user test?
So when we're considering the relevant prior art and for the three-way comparison, you are certainly looking at the nature of the underlying article. You're not going to be pulling in designs from completely separate art areas, unless you can argue that exact design or substantially identical design exists somewhere else. In other words, in a pure anticipation or novelty argument, you can pull in art from other areas. But if we're talking about a furniture unit and we're arguing that it should be invalid because this design would be an obvious modification of two references, then you have to look at articles that are of the same character as the patented design in order to attempt to combine them. And you have to find I didn't discuss our obviousness standard, but it's essentially you have to find a single reference that has basically the same design characteristics. And then if you want to attempt to make the argument that it would have been obvious to a designer of ordinary skill to modify that to reach the patented design, you have to come up with some reason why they would do that. Why they would take this other feature from a secondary or tertiary reference and modify this primary reference that has basically the same design characteristics to result in the patented design.
And George, could you explain us about the second part? Do you think that this is comparable with the definition of the degrees of freedom of the informed user test?
I think it's possibly more comparable with the design, looking at the design corpus, but I think that does have a bearing on the degree of freedom. I mean, if you look at the design corpus, and a lot of the design corpus has a same feature, then that's usually an indication that there is some sort of limitation on the degree of freedom. So if all the prior art has a particular feature, there's usually or often an underlying reason for that, and that might be that there's some sort of constraint on the degree of freedom.
Marina, I have a follow-up question to James related to this one. James, I was thinking about the ordinary observer test that's from the 19th century, and now at the 21st century we had this kind of modification of the test, and I've read some papers that says that after this modification, we don't have anymore the ordinary observer test. We have this extraordinary observer test, criticizing the decision. Do you, in your personal opinion, of course, do you think that after the Egyptian goddess decision, the ordinary observer test is more similar to the informed user test, or no? Or do you think that they are extremely apart, how they work at the past?
And from everything I've read, and including that same article, and my understanding of U.S. case law and the outcome of many cases and European cases that I've looked at, I think they're pretty similar. I do think the informed user test is somewhat more strict still. It requires a higher level of knowledge of the art. It's a somewhat more sophisticated purchaser, or excuse me, individual who has more extensive knowledge of the design corpus than what is required. So it's not unreasonable to call it an extraordinary observer, but it's considered, I think it's a bit of a stretch still. It's still a observer. It's still a purchaser of that type of article who's done their homework, right?
Yeah,
who's looked around and seen what's out there, right? In that art area. They're not a designer. They're not an expert level person who's zoomed in to every feature at 1000% and looked at exactly what the edge curves look like and things of that nature. It's kind of the sophisticated consumer of that type of product who's done their homework, looked around at the various options, maybe done some side-by-side comparisons if that's feasible, in a store. Hey, look at these, which ones do I like better? But not necessarily. And so I think they're close, but informed user test requires a somewhat higher standard.
Yeah, I have the same impression. George, I've read an internet article, and the guy says that the informed user is kind of a fussy consumer. It reminds me of Apple consumers. People, they are really fans of the product, kind of. So they are a level above the extraordinary observer.
Yeah, I mean, I'd agree with that. I mean, we've had guidance from the Court of Justice on this one, that it isn't just an average consumer. They do have specialist knowledge, and they are quite attentive, and they're more likely to know the design corpus and spot striking differences. And they're performing a side-by-side comparison as well, which makes it easier to spot differences. On the other hand, as we discussed, they're not an expert. They don't manufacture these products, so there is a limit to their know-how. They're not going to zoom in on the minute details
with a microscope. Okay, yeah.
Nice, thank you. That's a very nice explanation. I have another spot for you, George. Regarding the degree of freedom concept, you invited us to make a question: how many different shapes or appearances can product have whilst still achieving some function? It is interesting to notice the correlation with function in this analysis. How do we define the way that functionality is analyzed in the informed user test? In addition, James, at some point, is this functionality also confronted in the ordinary observer test? And to conclude, how the functionality affects the analysis of infringement in Brazil? What do you think about it?
Shall I go first?
Yeah.
So from a European perspective, functionality is an interesting one. We have the exclusion. I mentioned that if a feature is solely dictated by technical function, it will be excluded. That is if there's no sort of underlying aesthetical consideration into this feature, then it won't be afforded protection. And then for features that aren't excluded by that provision, we still assess the degree of freedom the designer had. If there's a low degree of freedom due to either technical or it could be actually statutory constraints, then there'll be a relatively narrow scope of protection will be afforded. So if and what I mean by that is if there's some sort of underlying law that requires a feature to be a certain way, that could be taken into account, like some sort of health and safety provision, for example, that requires products a certain way. But we're also looking at usually some sort of technical considerations. In the case of the iPad and Samsung Galaxy Tab, I mentioned that the rounded corners would be an example. You wouldn't usually make these devices have a very sharp 90-degree angle. So there's some constraint there. It's difficult to quantify how many shapes exactly are required for there to be a lot of degree of freedom, but the court's just got to assess this on a case-by-case basis. As I've mentioned already, if a lot of the prior art has the same feature, that usually implies that there is some constraint on design freedom there. And we've also seen companies try and rely on other definitions of functionality. For example, branding. There was a case involving Porsche's community design to their famous 911 sports car. Now, this has had a number of design iterations over the years, and it's quite difficult for them because they've got to update the car and refresh the looks, but they've still got to keep that sort of classic look of a 911 sports car. And they tried to argue that there was a constraint on the degree of freedom because the designer had to make a Porsche look like a Porsche. So although it wasn't a technical consideration or a legislative consideration, nonetheless, certain features had to look a certain way because a consumer expected them to, and that didn't fly with the court. They didn't buy this. In the end, the 911 RCD was found to be invalid over a previous 911 design. Just like it lacked individual character. The differences were too slight.
Just responding quickly, we don't have a functionality test for design patents. We have an ornamentality eligibility prong that you have to check for designs in the US. So the question is, was something done for the purpose of ornamenting? And in George's presentation, he talked about parts of complex products that are hidden during normal end use. That would also be something that would indicate that a design is not ornamental in the US unless you can establish that it mattered to somebody at some point during the normal life cycle of that thing. Or if it's the type of product like a septic tank or a body implant that's hidden during its normal end use, but maybe the design of it matters to somebody at some point during its normal life. Maybe it matters to doctors who go to trade shows and want to pick out which hip implant manufacturer they're going to buy their products from. Maybe they like the look of one versus another. So it could matter to them. And so it's not a real high hurdle in the US, but that's one area where there could be a holding of non-ornamentality and therefore ineligibility. And then the overall test, I discussed it briefly already, which is it looks at whether the overall design is purely dictated by functional considerations. The degree of freedom matters in that analysis, of course. And in fact, the most recent Federal Circuit case talking about functionality, and I have a whole separate presentation on this, is for one of those child's flotation devices with the chest piece and the arm cuffs. And there are some regulations on how those have to be designed, with the buckle on the back, for example, and the overall ratio or dimensions of those pieces. So there were some limitations on that category of product. And of course, the design patent can never protect a function, and therefore somebody else has to be free to make that category of product. And however, there is still some freedom in the taper of the arms and the exact ratio of these things, and on surface ornamentation that might go on it. And so very similar to how George discussed this in his presentation, you can have very narrow protection, and there's the courts will kind of err on the side of finding that, assuming there's alternative designs exist, we can have a very narrow protection, and multiple designs can coexist. And so, narrow the protection, the less likely there's going to be a finding of infringement if certain elements of a design kind of have to be there. But again, we're looking at the overall claim design, and even these functional things, there might be some degree of freedom in where you place these purely functional things. For example, the plug on a device. Where'd you put the plug? Where'd you put the charging port? Things of that nature. There may be, and often is, some design choice in that analysis.
I believe we have a kind of different situation in Brazil related to functionality. In Brazil, functionality is extremely relevant for the invalidity test. So according to the Brazilian law, if a design is mainly functional, so it should not be granted. I think it's different from what George said, because George said it's solely functional. I don't know if it was rhetorical or just a misconception of the word. But in Brazil, if it's mainly functional, we should not grant the design. The problem is that after the design is granted, we don't talk about functionality in the infringement test. And we have a huge problem in Brazil because the designs are granted, the industrial designs are granted automatically by the Brazilian PTO. So we have a lot of designs that are automatically granted. So a lot of them, or not most of them, but some of them has this issue related to functionality. But if the proprietor of the design file a lawsuit, an infringement lawsuit, the courts, most of the time, they believe that if it was granted, it should be protected. And we are not going to talk about functionality because functionality is related to invalidity. And in Brazil, until the present moment, the state courts that deal with infringement lawsuits, they are not allowed to analyze and arguing related to invalidity of an intellectual property right. So if you are a defendant, you have to file another lawsuit in a federal court arguing the validity of this industrial design related to the presence of a mainly functionality aspect. And then you have to pray for the federal court to be faster than the state court and to nullify the industrial design and not be ruled against you at the state court. So it's kind of a tricky situation in Brazil.
Nice, interesting. We already have some questions from the audience. We'll open at the end for these questions. Now, I would like to invite Mr. Raul Murat to talk a little bit about the infringement tests.
Okay, let me share here with you. Just a moment. I think it froze, but it will come back at some point. Okay. Just a minute. one more minute. I think it will come back soon.
Okay.
Okay, now. So Marina asked me to talk about the Brazilian perspective and show you guys if we have the adoption of the ordinary observer test or the informed user test. So as you can see by the title of my presentation, I'm kind of not sure if we have a Brazilian perspective. I'm going to be brief. I'm going to try to talk in 5 minutes, 7 minutes, something like that. Let me put a timer here. And because I saw that we have a lot of questions, and then they are more important for the debate. So what I tried to do was to make a kind of brief and profound research at the same state court of Brazil. I chose the state court of São Paulo because it's the biggest state court related to conflicts of intellectual property, and it's the state court that has the best search engine. So it was easier to search for the case laws at the state court of São Paulo. And what I will show you guys is that at the same state court, we have not some, but a lot of debate related to the way you analyze, the way you verify an infringement of a industrial design. I've brought 4 lawsuits, but I will be really brief. The first one is this one related to a bottle of water. I've made some graphic presentation to you. So we have this claim design from the bottle of water Santa Inês and the accused design from the bottle of water Aquissima. If we compare both of them, we may think that there is an infringement because both of them, they are bougie at the middle of them. They have these 3 parts at the end of the bottle. They have this long neck. And at the first glance, we could believe that there is an infringement. And I tried to present them as an informed user. So presented them as an informed user, we could think that maybe we have an infringement because, of course, there is some constraints at the freedom of the designer related to the corpus, because a bottle of water is a bottle of water, but most of the bottle of waters, they are not the way those two, the claim and the accused design are. They are a whole long bottle of waters, and they have in the middle, they have a place for you to handle, to grab, to hold the bottle of water. Extremely different from the other two. It's kind of funny because the other two, they seem not to be very ergonomic, because most of the bottle of water you have an easy way to hold at the middle, and these two, you don't have that. So maybe for any informed user, taking a look of the bottle of waters, and it could have some kind of likelihood of confusion. And I try to believe that some people that buys bottle of water, they're not that informed, because you just buy water. You're not an aficionado of water. I know one person that used to be the deceased Denis Borges Barbosa. He used to be an aficionado of water. He loved water, but he was the only person that I knew. So, and I played a little bit more, and I tried to present it, but using the test related to the ordinary observer, but not the original ordinary observer, but the ordinary observer that looks the prior art. And as you can see, we have this bottle of water Tinan. This is the prior art. It's quite similar from the accused design. The accused design is quite similar from the bottle of water Tinan. Actually, the accused design is more similar to Tinan than to Santa Inês, because as you can see at the middle of them, they have some discrepancy in which part is the bougie part of the bottle of water. In Suprema, Suprema Santinês is closer to the bottom of the bottle, and its Aquisma in Tina, it's closer to the upper part. So Aquisma it's closer to the prior art than the claim design. What was the decision of our State Court of São Paulo? It's interesting because we had a decision by majority and not a unanimous decision. So the court ruling was that there was not infringement. So they believed that the consumer was an average consumer related to the relevant market, not an informed one, but they believed that the consumer should be able to compare the bottle of waters of the Brazilian market and the international market. They kind of made some evaluation related to the invalidity test. You know, we have to take a look at the whole prior art. And then they believed that there was this more similarity with the prior art than with the claim design. So I think that this was some kind of ordinary observer-ish test. You know, they did not apply the test, but in their confused ruling, we could extract this information. But there was a dissenting opinion by one judge, and the judge has applied what I think was the raw ordinary observer test, the first one, the one that was from Warren vs. White. They believed that there were a lot of bottles at the market, and most of them were extremely different. And even if you have this prior art, most of the bottle of waters at the market, they were not similar to the prior art. So if a consumer goes to a supermarket and buys a bottle of water, they will have it will have a likelihood of confusion because the accused design and the claimed design are extremely similar. It reminded me of the paper that I read that he says that we must analyze the industrial design protection using the sensibility of the everyday life, the sensibility of the everyday person. This was supposed to be the main core of the ordinary observer test, and it was what the dissenting opinion believed. I'm going to be really quick. We have this other lawsuit. This is related to paper towel. We have this pattern in a paper towel with round areas, and the accused design, this was the paper towel Donna. It's interesting because the ruling of the court was for the absence of infringement. And why was that? I believe that they unintentionally, they have applied the informed user test. What they said that whenever you analyze a paper towel, whenever you buy a paper towel, you will buy a paper towel at a package with 2 paper towels, and you will only be able to take a look at the pattern of the paper towel when you open the package. So if you have a consumer that is really attentive to the package, to the pattern at the paper towel, this consumer is an informed consumer that knows what he or she is buying. We have actually this part has some prejudice at it, because this part says, okay, just housewives and domestic servants buys paper towels. So this is not the reality, but it was what they believed. And we have the evaluation related to the freedom of the designer. They said, okay, we are talking about paper towel. There is not much you could do at a paper towel, and so there should be not an infringement. It was kind of an informed user test. So at the same court, we have this application, we had this using of two completely different parameters for evaluation of an infringement. So is it all? No. At the same court, we have a lot of rulings, a lot of case laws that does not specify which consumer we are talking about. As you can see by this part, they said, in disregarding the expert was an expert nominated by the judge, was conclusive in listing the various differences between the shoes produced by the plaintiff, also stating that the products do not cause visual confusion before consumers. Which consumers? We don't know. In addition, it's clear from the extra report that there is no substantial imitation, being fully possible and for an observer to perceive them from immediately. Who is the observer? Who is the consumer? We don't know. Most of the times, the judge and the courts, they just nominate an expert. Some of the time, the expert is an engineer. Some of the time, the expert is a designer. We have situation in which the expert is a lawyer. So the judge nominates a lawyer as a third part to do this research, and the expert will choose which kind of consumer they will believe that will take a look at the designs. Is it all? No. Just last but not least, the same court has ruled about this case. We had this claim design, this kind of free will in which you put up the package for kids to, I think, to facilitate the kid to stroll with the package, backpack. I think so, because it's a bag really big for a kid. So maybe you need wheels just to traverse during the various places in Brazil. It's interesting because the ruling of the court was based on these key factors here presented to you. A granted design must be enforced. So the court has appreciated as a design as a property, as a title, something that you have to enforce if the Brazilian PTO has granted. The court must assert if there is substantial similarity. It didn't explain how to assert the substantial similarity, and didn't explain by which focus we should take a look at the substantial similarity. And the court has not made any specific analysis related to the likelihood of confusion or even the eventual functionality of the design. What we could conclude from this ruling is that the court simply believes that if there is some kind of objective similarity from the accused design and between the accused design and the claimed design, we have an infringement. We don't have to talk about the perspective of a consumer. We don't have to talk about the perspective of an informed or observer consumer. If they are similar, even though the similarity is related to some functionality, even though we have some prior art, and the defendant showed you have some prior art with 5 wheels, even though we have some prior art related to the matter, this is irrelevant. They are similar, so we had some kind of infringement. Then, as we can conclude, at the same state court, we had various ways to analyze and to verify if there should be an infringement of an industrial design. Then what I can say to you is that in Brazil, we don't have a kind of a Brazilian perspective or a main way to appreciate an infringement. This is fantastic for lawyers because you can just use every thesis that it suits better your client. but this is not good in a safe way to travel during the sea of competition. That's it.
Thank you very much, how it was explained in the presentation. All the cases. We have some questions here addressed to you. The first one is from Carlos Mauricio Ardissoni to George Hudson. Did you read the question, George, or would you like that I read for you?
So this is a question about submission of evidence around the informed user. I mean, this is an interesting question. It can be difficult because the informed user isn't a real person to try and submit surveys, for example, or an opinion of one particular expert and try and pass that off as the informed user. I mean, in the Porsche case I mentioned earlier on, one of the strategies Porsche tried to employ to argue that these two designs to the 911 were different was that they conducted a survey of sports cars enthusiasts who sort of picked up on the fact that these two 911 designs were different, and they tried to submit this as evidence, and the general court just didn't buy it. They said, look, the informed user isn't a real person, so you can't just sort of rely on survey evidence here to argue that they would be aware, they have a certain degree of knowledge and they'd be aware of differences. It doesn't really work like that. It has to be an objective test through the eyes of the informed user. So having survey evidence isn't always that helpful. I'm not sure actually on the question of forum shopping, which is implied here as well. So sort of going around different member states and sort of until you get the answer you want, you know, asking Spanish consumers and Italian consumers, and then sort of starting an action in that country. That's quite an interesting question. I haven't encountered that before, but like I said, that there is a hesitancy for the course to put too much weight on sort of actual the opinions of sort of real consumers, as opposed to the informed user who has a sort of certain attention to detail and all the other factors we just discussed.
Thank you, George. We have a second question from Claudio Tabas for everybody. Did you read it, or would like that I read for you?
Claudio Tabas.
About existence of grace periods and what acts are excluded from the grace period. I actually answered. I didn't mean to hit enter on that. I typed it out in case we ran out of time. I was going to at least send the answers, but I answered. And in the US, you have a grace period. It's 1 year, 12 months for any activity by the inventor or someone who gets the design from the inventor. So for sale, offers for sale, publications, etc., are all okay.
Yeah, in Brazil we have a grace period too, but the grace period is smaller than from the one at the US. I quite don't remember the
108 days.
108 days. Yeah, that's it. 108 days.
There's a bit of confusion related to the 6 months and the days. You know, it's a point interesting related to Brazil.
I was going to say it was 6 months, but it's actually exactly
180 days. Yeah,
okay, yeah. That's good to know.
Yeah, we have 12 months for patent and 180 days for industrial designs. Okay. And you have, when you apply for the industrial design, you have to request the grace period before the Brazilian PTO. You know, if you apply and you do not request and the industrial design is granted, and after that, a competitor file a lawsuit trying to nullify your industrial design, most of the people believe that you are not going to be ingratiated with this grace period because you had not requested it from the Brazilian PTO at the beginning.
Interesting. I've had it happen in the US where a salesperson goes out and shows a product. They don't know it when we file the design patent application. We can always rely on the grace period. We don't need to tell the US Patent Office, hey, there may have been a disclosure in the last year. Sometimes we do that just proactively. We'll file an information disclosure statement that says, hey, this is not prior art because it was a disclosure by the inventor less than a year ago. But just to let you know, And really, it's my reason for doing it is not only thinking about future potential litigation, but I don't want the examiner to find a website or something and then assert it against the application during examination. I want to let them know that, hey, if you do find that, that's our disclosure. It was made less than a year ago. So look elsewhere, try to find the art elsewhere, if that's relevant, right? If it's a publication that is findable on the internet.
In Europe as well, we have a 12-month grace period. Again, it's for disclosures made by the designer. So the problem there is, there's a 12-month grace period, but the advice always is file your application as soon as you can, because the third party comes along and they've independently conceived the same design, then the grace period wouldn't protect against that. So that would invalidate the later registered design filing.
But that's only for, George, that's only for truly independent designing event, right? Of the same exact design. It's not if somebody gets it from you, right? If somebody steals the design off your desk and then publishes it, that would be part of the grace period, right?
That's right, yeah.
Okay.
Interestingly, I've seen cases where a sort of third party has filed an application, and then the rights holders come along and said, look, we've disclosed 8 months before this, and this is clearly they've copied our design and they've filed an application. In that case, the action to revoke the design has failed, because the later party can rely on the grace period themselves, because of the way the law is set up. It's actually a question of entitlement. They're not entitled to that later application, but they can actually themselves take advantage of that grace party provision in the circumstance you just mentioned.
Thank you. We have more questions from Eduardo Fonseca for Mr. James Aquilina. James, did you read it, or you would like that I read that?
Yes, I think the question is asking, if you have a continuation or the divisional design application, can you bring up the parent application? Meaning, I think the question is, can you bring it up during the assertion of the child application or child patent to prove the scope of the asserted one? I mean, if you have infringement of both, which happens quite often because we have partial design claiming in the US, then you would just assert both from the outset, right? If you have my first application is for the entire mug, and then my second one is for just that upper part, and the third one is just for the handle. If there's infringement of the entire design, then I'm bringing all three, and I'm asserting all three patents against this product copy. If I understand correctly, the question is, can you bring up your parent design patent as prior art to help establish the infringement? And I believe you could, as part of establishing the ordinary observer test, you could use your first filed kind of parent application that had a broader scope that issued, or more narrow scope that issued as a design patent, and establish that this is something that's in the prior art. Again, if the design was known at that time, right? If there was, this is the interesting interplay here of the grace period, right? Because if you have a public disclosure of something, the design is out there, and the inventor can rely on the grace period for filing. It's not going to be prior art to its own application, but if there's a CIP, we don't really have CIP design applications in the US. You can file them, but you're either entitled to the initial filing date or you're not. And if you're not, then it's really not a CIP. It's a new application. And so your parent application can serve as prior art against your own later filing if the initial filing doesn't have the complete disclosure. This is a very complicated question. I won't keep droning on here, but long story short is, yes, you could bring it up, but for a very nuanced argument.
Thank you, James. There's another question, and it's interesting because it's related to the spot That's what I was intending to do, but we didn't have so much time. So it's from Carlos Mauricio Ardissoni. It's from Mr. James Klina and George Hudson. It's about the dynamic graphical interfaces. Are they protected as industrial designs in the US and Europe? George Hudson talked a little bit about it. And would you explain more?
Yeah, I can expand on that. I mean, this is, as we discussed, yeah, it's although there's this computer programs exclusion, it's only covering the underlying software code, which is covered by patent and copyright. Graphical user interfaces are protectable. This question relates specifically to dynamic interfaces. So I understand that as being sort of animations, and they are also protectable. It's a bit of a challenge because you've got a number of static representations and you're trying to convey movement with them. And there's a requirement by the office that the order you have the views that does display a clear progression, but it's perfectly possible. In Europe, I think it's currently limited to seven views for a registration. In the UK, we're actually allowed 12 views, so you could have a slightly more complex animation. But yeah, it's entirely possible, and we do see more and more of these sorts of filings.
Yes, we also have them in the US, and we have no limitation on the number of views you can show. You can arguably obtain a broader protection by having fewer views. If you know, the old one of the earlier ones was the Apple slide to unlock, and there were 3 views, and you would go across the screen. It was one in the middle, and then one, you know, then all the way. Then there's another patent that shows 1, 2, 3, and then a 4th figure of the screen unlocked, the phone unlocked, and so you had something of a somewhat more narrow scope there. And the way we file these is pretty straightforward. We only need to show the perimeter of the screen because it's considered surface ornamentation from an eligibility standpoint. We show in solid lines what the claim is. We have to show them in the order of progression, as George said. But then we have to include a statement that says the appearance of the design between what's shown in the figures forms no part of the claim design, because you can't speculate and you can't have a range of design patent claims. You have one design patent claim, and it's what's shown in the figures and described. And so it's there to there to there to a 4th view if there is one, et cetera. But we could have 20 views if you wanted to have a really show a really complex graphical user interface that's dynamic or animated in scope. On the copyright question, because we also got a copyright question, I think it was more for Raul, and I won't eat up all his time, but we can have overlapping protection in the US too, because we can have copyright protection in source code, but that same copyright registration can also extend to the screen displays that would be outputted after that source code is compiled and run. So what they actually look like is actually could be unknowable from what's submitted. It's a very interesting loophole in the US copyright law, but something to keep in mind if you're trying to advise clients on this. There could be overlap of screen protection with copyright and design patent law in the US.
Thank you, James. Thank you, George. There's more questions. The question is from Aline Ferreira de Carvalho for Mr. Raul Murat. Raul, did you read it?
Okay, yeah. Related to the overlapping protection of industrial design and copyright. This is a really serious matter. We have this kind of claims in Brazil, most of them related to furniture. So we have these armchairs and these chairs, these sofas, these dinner tables that they are initially protected by industrial design, and then the designer becomes really famous, and then they believe that the sofa or the armchair, they are some kind of work of art, a piece of art. There is one related to Sérgio Rodrigues. He has this armchair called Mole, and a little one called Moleca. And they actually are quite good. They are really comfy. When you sit there, it's very difficult to get up because they embrace you, and you just want to stay there drinking a whiskey and reading a good novel. But the problem is, I have this interpretation that I follow what Professor Denis Barbosa used to write about it, and I have the same conclusion that my partner Pedro Marcos has recently written related to this overlap protection. And I believe that their function are completely different. You know, for copyright, we protect the aesthetic matter of the creation. And for industrial design, we protect the ornamental matter of the creation. And our constitution is based on the liberty of competition and the liberty of initiative. And it's against our constitution to try to extend or to expand the protection. If you have chosen to protect your creation with industrial design, your creation will be protected with industrial design. And at the term of the protection, there will be no more protection. I think this is the interpretation that best suits our Brazilian constitution. This is not what's happening around the world. George maybe can talk more about it. We have some debate related to it. The European Court has just recently applied the protection of copyright to a kind of bicycle, a bicycle that you can fold the bicycle, and they believed that the bicycle is a work of art. And during this matter it's more serious than the overlapping protection between copyright and industrial design, because this bicycle was protected by patent at some countries. So the functionality, the technical aspect of the bicycle was really enhanced at the product, but the court believed that this bicycle is actually a work of art, and then it should be protected with 70 years after the death of the creator. It's problematic, I think.
Yeah, I'd agree that there is potential problem areas here, and it's something we're going to have to keep an eye on. I mean, it used to be the case, there was a Supreme Court decision in the UK that basically said works had to have sort of artistic character, and getting copyright protection for sort of shapes was very, very difficult. But we had two cases actually in Europe that have kind of turned this a bit on its head. The first, we had the Confell decision, in which it was decided that the same criteria must apply to works of art as for other categories of work. So they're protected if they're the author's own intellectual creation, which is a relatively low threshold. Additional criteria, such as requiring that the works were artistic, for example, so no longer applied. And then, yeah, we had the Brompton decision. This is the folding Brompton bikes case. And it was held that if a shape expresses creative choices made by the person designing it, copyright can apply, even though the shape is, at least in part, mandatory for achieving a technical result. And as you pointed out, the issue there is that the significantly longer term of protection available of copyright than patent law and even design rights.
Yeah, that's it.
Thank you. That was nice. We have a last question from Jordi Well for Raul Murat. Raul, did you read it?
Yeah.
Okay.
Jordi, I have the same feeling that you have. It used to be this way. So if someone filed a lawsuit related to an infringement of a automatically granted industrial design, the defendant could just argue that the industrial design was invalid, if it was, of course, and the state court could appreciate this argument and not invalidate the design, but do not put the design in effect against this infringer. Sorry. But this is not what happens nowadays, because our Brazilian Superior Court has modified interpretation, and now they believe that every claim related to an invalidity of an industrial property must be presented at the federal court with the participation of the Brazilian PTO. Then, if someone files a lawsuit related to an infringement of an industrial design, even if the industrial design was not substantially examined by the Brazilian PTO, the state court shall not appreciate any claims related to the invalidity of the industrial design. We had one different ruling at the same superior court in 2020, but this is just one different ruling. Most of the rulings are impeding, they are an obstacle to the appreciation of the invalidity claim or arguing at the state court. Therefore, if you are a defendant and your main thesis of defense is related to the invalidity of the industrial design, you have to run as fast as you can and file a lawsuit at the federal court and try to be granted an injunction at the federal court that will suspend the effects of the industrial design. That's what you can do, and that's what people do.
Thank you, Raul. There's one last comment from Claudio Sabas, but it's about functionality and how is the time short. I should finish now because this discussion is a long discussion, but it will be a pleasure to answer you. I can follow the question for the panelists as well by mail. So now I would like to say thank you for everybody. It was a pleasure to be here with you today, and I hope we'll have next opportunities to talk about design. Thank you for the panelists and thank you for the audience.
Okay.
Thank you, Marina. Thank you, everyone.
Thank you, Marina. Thank you, everyone. Thank you for the invitation. It was really, really nice.